Further hearing in the appeal of Sharp Co Ltd against Viterra BV, previously known as Glencore Agriculture BV.
Mr. Carrier.
May it please your lordships, before I turn to addressing my learned friend's appeal, I have 4 points remaining from yesterday on our cross appeal. Firstly, I took you to the judgment, so if I could ask your lordships to turn to page 157 of the electronic bundle. That's the Court of Appeal's judgment.
Set it up in future so I can see it on the screen.
Yes.
Sorry, thank you.
I was just waiting for Lord Legate's computer
I'm
to
there
be
now.
running. I had taken your lordships to the top of that page, which is paragraph 49. I would also like to take you to a couple of sentences of paragraph 50. It's really the first 2 sentences. Mr. Karia KC submitted that the statements about a notional substitute contract were confined to cases of anticipatory breach, which, as Lord Sumption observed at paragraph 13, give rise to particular problems of legal analysis when it comes to the assessment of damages. However, it is impossible to read the passages in question as so limited. And the final sentence, the paragraphs I have cited above addressing a notional substitute contract as a surrogate are part of the more general reasoning applicable to cases of actual breach. It is the use to which the dicta in Bungie and Nidera was put in that paragraph and the preceding paragraphs that we say was erroneous.
I think it was applicable to actual breach. There's nothing wrong with applying it to actual breach.
Yeah, yes, but not on the facts of this case.
Well, I think all a substitute contract means is you instead of selling the goods in this context to the to Sharp, you sell them somebody, enter into contract, sell them to somebody else.
Yes, and
Nothing wrong with describing it as a substitute contract.
yes, but it's what the Court of Appeal understood by that term, and what they understood by that term is...
I know, well, they added in all the terms of the original contract.
Yes.
So far as I can see, there's only one sentence in Bungie which has that in it. One sentence of Lord Sumption's judgment. Yeah. All the other references are simply to a substitute contract, which seems to me perfectly innocuous.
Yes, and indeed, I think I did submit yesterday that all mitigation will require a substitute contract. Yes. You know, whether at the destination or elsewhere. So it's not the question of substitute contract; it's the terms upon which. So anyway, that's...
I mean, your objection is...
What Bungie was concerned with was assessing what the innocent party had lost in an executory contract,
yes,
which was the benefit of the contract. And what they were seeking to do is create a substitute contract on the same terms, which would expose the innocent party to the vicissitudes of commercial life.
Yes.
Yeah. But that has no relevance at all in this context.
Yes.
Yeah.
And that is what we had submitted and what we submit.
Yes.
Thank you, my Lord.
Your objection is not to substitute contract per se, but to substitute contract on all the terms of the original contract except as to price, which is the full formula which got applied in this case.
Yes, yes, my Lord. That takes us to my Lord Hamblin's question about the Eleanor D'Amico. That appears at page 772 of the authorities bundle. That was
in the electronic.
The original, the main bundle.
Yes, I apologize. Electronic bundle. So 772 is where the report starts.
Yeah.
That was a repudiatory breach of an ongoing charter party. The relevant passages for present purposes are on page 784. And on the right-hand column, right at the middle of the page, starting with the words, taking again the case of non-delivery. Your Lordships have that.
Yes.
Taking again the case of non-delivery where goods are not delivered on the due date or the contract is repudiated, the buyer is placed in a situation where he has to decide whether or not to buy in, and if he's going to buy in, whether he should buy in immediately or wait for a time to buy in later. The position in law appears to be that, generally speaking, if there is an available market for the goods in question at the time when they ought to have been delivered, then if the buyer decides not to buy in on that date, which he is fully entitled to do, he cannot visit the consequences of that decision upon the seller. And there are similar passages, my Lord, on page 786. But we don't need to turn those up. So as I understand it, that's the crucial principle from Eleanor D'Amico, and we'd make 3 submissions on that principle. Firstly, it confirms what we have already seen from Radford and de Froberville and from Lord Brown's speech in the Golden Victory, that mitigation and measure of damages, though conceptually distinct, are mirror images of each other. Secondly, there's no suggestion anywhere in the judgment of Mr. Justice Robert Goff that you are looking at different markets for mitigation, one market for mitigation, one market for measure of damages.
Well, it goes rather further than you're putting it. It's not just it doesn't say that, it expressly explains how mitigation is the underlying principle.
Yes.
And that, in turn, is a facet of causation, he explains.
Yes. Yes, my Lord, and we would adopt that. And again, thirdly, there's no suggestion of replicating the original contract. This was a partly performed charter party, and there was no suggestion that you had to somehow go back in time. Now, obviously, a charter party is different from a sale of goods, but insofar as Mr. Justice Robert Goff is using that analogy, so we would adopt what my Lord Legate has said and say that this authority supports us.
It's really the explanation of the Sale of Goods Act and the principles underlying it.
Yes.
Yeah.
And it's linked to mitigation.
Yes.
Like it says.
Yes. So where you are able to mitigate, you are deemed to mitigate at the first reasonable opportunity. So, and we know that that may not necessarily be exactly on the day, it may be a few days later. See Lord Scott in the Golden Victory, for example. But it's deemed mitigation. And if it is deemed mitigation, then it has to be on the same market as actual mitigation would have been.
Well, actually, that's not necessarily true, I don't think. What the person actually does may not be what a reasonable person would do.
Yes. But
so there can be cases in which somebody doesn't sell in the available market when they should.
Maybe I should put it this way. The deemed mitigation is predicated upon a reasonable person actually mitigating under those circumstances. So it may well be that a reasonable person, because of various problems in the local market, may not mitigate in that market. So that's the comparison.
I mean, one can imagine a situation where on a buyer's default, so a seller is left unexpectedly and unintentionally long the market, he may actually mitigate by going short somewhere else and effectively square his position without necessarily having to do so in the very market in which the goods happen to be situated at the time.
Yes, but in the sale...
We're not concerned with that sort of situation here, I don't think.
No. And under the Sale of Goods Act, those are commercial decisions that the innocent party makes for its own account. Yeah. That's what Mr. Justice Robert Goff says. The law takes a very simple attitude. If there is a market, you're presumed to go into that market and mitigate there. If you do anything fancy, go ahead. You may make more money, you may lose more money, but your opponent is not going to be liable for it. 2 very minor points, just references. I had mentioned yesterday about the number of GAFTA forms that contain the default clause, either in identical terms or similar. The number is 64 out of 78 GAFTA forms, and the reference to that is the submissions bundle. You don't need to pull it up. Submissions bundle, page 82, paragraph 3.3. And one final reference. I was searching yesterday for a reference where my learned friends, the third reference where they refer to the common law, and that's in their supplemental written case. And the reference to that is Appellant's supplemental bundle, pages 93 to 94, paragraph 34.2. And what they say there is, in response to my submission that the construction placed upon the goods in these circumstances by the Court of Appeal was very unlikely to occur to a GAFTA commercial person or reasonable commercial person. They say the basis for this assertion is unclear. On the contrary, it is submitted that commercial persons and GAFTA traders are very likely to be familiar with the concept of measuring loss by reference to an equivalent bargain at the going market rate, not least because this is the ordinary measure of common law. And I've sought to show your lordships that replicating the original contract is not the measure at common law. So those conclude our submissions on the cross appeal. On the response to my learned friend's appeal, there are three issues. There's the question of refining the question of law. The second question is whether that question was put to the appeal board. And the third question, which my learned junior, Mr. Gardner, will be dealing with, is whether impermissible factual findings were made.
I'm sure Mr. Gardner's grateful for that.
Yes. We have his ankles tied to the desk here. So firstly, on the refinement of the question, as I understood the exchanges between my learned friend and the court, I understood my learned friend to say the words that have been added into paragraph 82 of the judgment, he has no objection with. I will address this point in any event, in case it is, but as I remember what my learned friend said, he says he doesn't object to those words, it's the use that the Court of Appeal made of those words.
Certainly if it had said on the facts found by the arbitration tribunal, there couldn't have been any objection. They're a little bit weaselly because they're saying in the circumstances or something, that it's sort of setting it up for the argument, sleight of hand that's going to follow.
Well, then I will take the refinement question very briefly. It's common ground that the principles to be applied are those enunciated by Mr. Justice Hamblin, as Lord Hamblin then was, in Cottonex versus Patriot. That again was a case where the question had been drafted in broad, generic terms, and Mr. Justice Hamblin held that it had to be understood by reference to the facts of the case.
Or the contract.
Of the contract, yes. And my Lord Hamblin said at paragraph 19 of that authority, although the question was framed in abstract terms, permission was obviously being given in relation to how that question is to be answered in relation to the contract under appeal. And that's the electronic bundle, pages 561 to 562. Don't think we need to turn that up. So the refinement of the question in our case, we see the words that have been added at page 166 of the electronic bundle. And at paragraph 82, and as my Lord Legate said, it refers to in the circumstances as found by the appeal board in the awards. And we say if and to the extent there is any remaining objection to reading in those words, they would be misconceived because firstly, Mr. Justice Jacobs would be familiar with the requirements of Section 69 and that the question of law should have arisen from the case. And secondly, it's very clear when one looks at Mr. Justice Jacobs' reasons, and this, it would be helpful to turn up at page 175 of the electronic bundle. So 174 is the first page of his order and reasons on the application for permission. And 175, at the bottom, we see at paragraph 7, Mr. Justice Jacobs says he grants permission to appeal in respect of question 1 because he considers it raises a question of public importance and the decision is open to serious doubt. And then he says, as has already been pointed out by your lordships, I would also, if I had not taken that view of public importance, have been prepared to grant permission on the basis that the decision of the GAFTA Appeal Board is obviously wrong. And then at paragraph 9, he addresses the award and the facts of the case. So he says the board held at paragraphs 7.28 and see also 7.31 that the date of the default in respect of which there is no appeal was to be determined by reference to the date when the sellers were able to obtain possession of the goods. And then he quotes from paragraph 7.28, which makes it clear that the sellers, Viterra, were not able to obtain the goods until the 2nd of February 2018. And paragraph 10, perhaps if I could just ask your lordships to read paragraph 10, that confirms that he had the facts of this particular case very much in mind when granting permission. Finally, on that point, on this point, we say that Lord Justice Popplewell was correct in paragraph 84 to hold that the reference to CNF free-out contracts in the introduction to the question of law was merely to explain the nature of the contracts originally entered into, which is necessary in order for the alternative bid to which the board adopted to make any sense. That's page 166, paragraph 84 of the Court of Appeal's judgment. So we say, to the extent there remains any objection to the refinement, that should be rejected. The second issue that I will deal with is the question of whether the question was asked in the...
That's the same question, isn't it? I don't say it's a different question. I mean, you can only refine to the... If it's accepted, the refinement doesn't affect the substance of the question.
Yes.
And you're dealing with the question that's,
yes,
been posed all the way up. It's just been wording slightly been refined.
Yes.
There is... Look at what they actually decided, though, wouldn't you?
Yes. So...
The question asked.
Yes, I accept that. I mean, what my learned friends say in paragraph 49 of their supplemental bundle, supplemental written case, is they say that the appeal board was not asked to decide whether the construction and effect of the LOI and addenda against the factual background of the discharge of the cargo was that the contracts ceased to be CNF contracts and became contracts for the sale of specific goods ex-warehouse Mundra, and did not make any decision on this question. I think, my lords, I have to accept that that question, as phrased in that way, was not put to the tribunal.
Well, it isn't a question that the court's asked to decide.
Well, it depends how widely in the circumstances of the case is understood. Certainly, the Court of Appeal understood that. So we're getting the relationship between the refinement and whether the question was asked.
I don't understand that, really. I mean, if we accept that the question that the court has to decide is the one that is modified by the Court of Appeal, that was the question they had to decide. If they start going off making other findings about whether the contract was varied and so forth, that's not deciding the question on the facts found by the appeal board.
Yes, even the amendment refers to the circumstances as found.
Yes. So what I would seek to show your lordships is the circumstances as found, even if the Court of Appeal's construction of the default clause were correct, did mandate and require the tribunal to value the goods on an ex-warehouse basis. And what the question asks is, should they have been valued on an ex-warehouse basis or on the basis of replicating a CNF contract? So it's important, if one looks at paragraph 8.
The point is, the Court of Appeal thought that in order to replicate the contract, they had to find that it had been varied.
Yes.
And so they embarked on a process of trying to extract from the award a finding that the contract had been varied, when in fact there was no such finding in the award.
Well,
and they arrived at it by making other findings which also weren't in the award.
My lord, I will try to show you that there was a finding of amendment and variation in the award. So if I could take you to that, and we can start that with your lordships. So if we start at page 214. Paragraph 2.3. Some of this your lordships will have seen, so I will take it quite quickly. This is when the tribunal recorded that the addendum of September 2017 and the terms of it, at page 226, which I think your lordships have also seen, paragraph 4, little Roman 2, one of the issues raised by Sharp was the relevance of the letter of indemnity and undertaking. And page 241.
That was in the context of liability, wasn't it? Not
Yes.
Damages.
Yes. But if we go to 7.24 at page 241, .24 says, having found above that the sellers did not waive their rights in respect of the goods or the non-payment clause of the contract, it follows, and we find that under the terms and conditions of the contract as amended by the addendum, the buyers were obliged to pay for the goods, the first installment of which was due on the 15th of October. So the tribunal were clearly alive to the fact that the contract had been amended and payment was to be made by way of installments. The next paragraph is on page 244. It's paragraph 3.5, and it's, perhaps I could just ask your lordships to read paragraphs 3.5 and 3.6. Sorry, I apologize. 7.35 and 7.36. I apologize, I misspoke.
Well, it looks to me as though it's finding that the contract hadn't been varied.
Yes, quite.
It was a contract for Canadian crimson lentils traded CNFFO Mundra on the international market.
Well, with respect, they had already found in paragraph 7.24 that the contract had been amended.
By the addendum, but that doesn't change the nature of the contract, which is the crucial question that the Court of Appeal saw it, as the Court of Appeal thought, from one that was CNFFO into one that was ex-warehouse.
Well, I accept that they were not asked to determine in the abstract whether that changed the nature, but they clearly found that the nature had been changed.
Not the nature, they simply changed the payment terms.
Yes.
That's all they're referring to here.
Yes, but they are referring to the addendum, which refers to payment out from the warehouse.
Yeah, but the crucial finding, or at least as the Court of Appeal thought it was crucial, was that the goods delivery had been taken from the carrier against the bills of lading.
Yes, that's the factual issue which we will get to.
But it was a factual issue which was the basis for their implied variation.
Yes, and I'm not going to trespass on my learned junior's domain, but...
Are you saying somehow it changed from being CNFFO into ex-warehouse without that?
Well...
So that was an irrelevant part of the reasoning?
One can see from the addendum and the fact that the goods had been landed that this was now an ex-warehouse contract with payment by installments. And
it doesn't tell you anything about the position as regards the carrier, does it?
Yes, and as regards the carrier, we say it is absolutely clear that the only factual situation that is consistent with the facts found by the tribunal is that the carrier had been given the original bills of lading and was no longer involved. The carrier could not possibly have been involved because...
And where do we find this in the tribunal's findings?
Well, my learned junior will take it, but
I know you're passing all the difficult questions.
Well, no, I'll explain. So, for example, I'll give you the headlines, my lord, right? So, for example, when letters were written asking for the release of the goods after default had been declared on the 9th of November, those letters were sent by the seller to the buyer. The ship owner is not involved at all. When an action was started in the High Court of Gujarat to secure the release of the goods, if they were held to the order of the ship owner must have been a party, would have had to be a party to that litigation.
But now you're in the business of drawing factual inferences that the tribunal simply didn't draw, and they weren't asked to draw.
Well,
this is where you get into finding the new facts, isn't it?
Well, my lord, we say it's
point
implicit.
To something about in the litigation, and you say, rather dubiously in my view, but you suggest that somehow you can infer from that a finding about what happened to the bills of lading.
Well, in my submission, in a situation where that is the only implicit finding that could be true, then it's implicit in the findings that have been made, and it isn't necessarily an inference. So, in our submission, if one looks at the facts, and one looks at the relevant paragraphs, it is clear that the ship owner is not involved at all in any shape or form from the moment of discharge.
It undoubtedly is an inference to say that because the ship owner wasn't joined to proceedings, that they didn't have an interest in the goods anymore. I mean, it simply doesn't follow. There may be other explanations.
But it's also, we submit, asking too much, particularly of a commercial or trade tribunal, to set out expressly everything which is obvious to both the tribunal and the parties. And
well, they're not to be criticised for it because it was never raised as an issue which they were asked to decide.
I accept that the question of how the cargo was discharged from the vessel was not a question posed to the tribunal.
Well, who was the contract of carriage with?
It would have been with the seller, because it's a CNF.
You were meant to become a party to the contract of carriage on paying against documents, weren't you?
Yes.
And that was an important right for you because risk had passed.
Yes.
So what happened?
Well, what happened is it seems abundantly clear that the goods were discharged against presentation of the bills to the ship owner. And we say that that is clear from the proper construction of the LOI. And we say that Lord Justice Popperwell's construction of the LOI and the addendum is correct.
It wasn't construction, though. You can't get that out of reading the document. He basically rectified the LOI without any evidence as to what it was actually meant to say.
Well, we hear what your Lordship says. We say that he engaged in the standard exercise of construction as exemplified in the Stars Inn, and my learned junior will take you to the relevant passages, including in the speech of Lord Millett, who deals with this in greater length. And we say that that's an exercise in construction and hence a question of law that the Court of Appeal answered. So I think I have been trespassing, and I'm happy to continue to do so, but is there anything else I need to say? But unless I can assist your Lordships further on the refinement question or the question of whether the board was asked this question. What the board, to just summarize, the board was asked, should these goods be valued? And this is the importance of paragraphs 7.35 and 7.36 of page 244. They were asked, should these goods be valued ex warehouse, which is the phrase that the board itself uses in paragraph 7.36, or should it be used, valued by a CNF FO Mundra on the international market? That was the overarching question that they were asked.
But your case before them was, there was no need to decide whether the contract had been varied or to answer that question. And that remained your case before the Court of Appeal, and indeed is your case before us, isn't it?
Well, I have to accept that it was never, the tribunal was never asked to determine whether there had been variation.
It's worse than that, though, isn't it? Because the answer that they gave assumes that the contract was not varied. They were treating the contract they thought they had to replicate as an unvaried contract. That was the whole premise of their award.
That seems to be what they're saying in the last sentence of 7.36.
And
that was how they justified the measure that they used.
Yes, and
they
my
thought
Lord,
they were replicating the actual contract, and therefore that it hadn't been varied.
And that is where they fell into error, because they themselves, in 7.24, had acknowledged that it had been varied, and that again is at page 241. I mean, if you could look at paragraph...
Well, they say that in 736, later amended by the addendum, but that's just the payment timings.
Well, They also have set out the terms on which the cargo is to be delivered as well, both with that and the LOI. So the references to that are at pages 214 and 218. So we say, taken together, there was a sufficient finding of variation, but then they fell into error by seeking to replicate CNFFO.
By forgetting about the finding they made silently earlier in their award.
Well, we say it's not so silent, but Your Lordship has my submissions. Unless I can assist Your Lordships further on those two topics, I will pass on to my learned junior. Okay.
Yes, Mr. Gardner.
My Lords, you have a preview of the issue I'm going to be addressing you on, which I think is the final one on Viterra's appeal, and that is if whether the Court of Appeal erred when answering the question of law by making impermissible factual findings in support of the conclusion that the contract was no longer on CNFFO Mundra terms on the date of default. And Viterra's complaint is that Lord Justice Popplewell strayed outside of the bounds of Section 69 by making two factual findings, which Viterra set out at paragraph 35 of their written case. I don't think we need to turn those up. I think Your Lordship saw them yesterday. The first one is that the word discharge was missing from the LOI. And the second one was that the cargo had been discharged from the vessel upon presentation of the bills of lading. I'm going to take those 2 points in that order, if I may. Dealing first with the LOI, we say this wasn't a factual finding at all, but rather an exercise in contractual construction. Mr. Carrier mentioned the stars in. Can I just turn that up briefly, please? It's at page 670 of the electronic bundle, behind tab 16 for anyone working in hard copy. It is, of course, a well-known decision about the construction of bill of lading terms. And one can see from the head note at page 670 at the very bottom under little 2, the clause 5 of the bill of lading into which words should be interpolated to remedy an obvious defect of omission could not be construed as a covenant not to sue. That's the relevant finding that we're concerned with. And 4 of their lordships considered this issue in their judgments. I don't think we need to look at all of them, but can I take your lordships to page 752, which is Lord Millett's judgment. And can I ask the court to read paragraph 192, please?
All based upon the practice of the Court of Chancery in putting right wills.
Yes, my lord. I'm hoping you're not going to ask me any questions about that. But the point that I take from that paragraph is that one can construe a contract in order to include a word that is missing from it. It is not necessarily an exercise in rectification, although I do accept that one might rectify a contract to include a missing word as well. I think that was my Lord Legate's point to Mr. Carrier earlier. It can be an exercise in contractual construction, and that's what the House of Lords was doing in the Stars in. Just for the court's reference, there's also discussion along those lines at paragraph 23, that's Lord Bingham, paragraph 53, Lord Steyn, and at paragraph 94, Lord Hoffman. Lord Hobhouse discussed the correction at paragraph 145, but doesn't really engage with whether it's a question of construction or not in that paragraph. I don't, as I say, I don't propose to take those up, but in my submission, what one can get from the Starsin is that it's legitimate to include a word into a contract where there is clearly a word missing as a matter of contractual construction. Now the Starsin was not a Section 69 appeal, of course, but in my submission, it is nevertheless clear that the process there was a process of construction, and therefore is one that could be done on a Section 69 appeal because questions of construction are amenable to appeal under Section 69. So we would say that insofar as the Court of Appeal answered the question of law by construing the LOI, it did not violate the Board of Appeal's role as the master of the facts. Can I now turn to what the Court of Appeal did? It might be helpful to start with the LOI itself, which I know we have looked at previously, so I won't spend too long on it, but if we could look at page 218 of the electronic bundle. That should hopefully be paragraph 3.15 of the Lentils Award.
Yeah. No, 218.
Sorry, my lord.
Sorry, which page are you on?
I'm so sorry, that's not a correct reference, but 218, yes. Mm-hmm. That is, perhaps it is the right reference. Yep. Page 218, paragraph 3.15.
Yes.
This is what has been termed the LOI. We say it's clearly a contractual document. The paragraph starts following a request from sellers. The buyers issued this letter, and we can see from the first paragraph that it contained a request for the sellers to discharge the cargo against the buyer's LOI in order to mitigate demurrage exposure. And then in the final paragraph, there's a confirmation by the buyers, Sharp, to comply with the above conditions and to remain liable for all consequences of not doing so. We do say this is a contractual document which can be construed in accordance with the principles in the Starsin. And it's common ground that something has gone wrong with the language here in the LOI. In the phrase, after cargo has been made with original bills of lading having been submitted to vessel's agent, because those words read literally don't make sense. In the Court of Appeal, there were two possibilities canvassed for the missing word, discharge and payment, and my learned friend yesterday suggested a third alternative, which is available. If we turn to what the Court of Appeal made of this conundrum, we can find Lord Justice Popplewell's discussion at page 162, I apologise, 163 of the electronic bundle, in paragraph 69. It's about halfway down paragraph 69, starting further. If your lordships have that to the end of the paragraph, that is the analysis that Lord Justice Popplewell gives as to why, in his lordship's view, the missing word is discharge. And in my submission, the exercise that the judge undertook in this section was an entirely orthodox process of contractual construction based on the words of the LOI and tested by reference to rival constructions or implications of the construction's discharge or payment. And if Sharp is correct that it was a question which the court could and should ask as to whether the contract was amended by the LOI, then in my submission it was necessary to embark on this question of construction of the LOI in order to determine whether it remained a CNF-FO contract after the LOI was agreed. So for those reasons, in my submission, this was not a finding of fact which falls foul of the limits of Section 69 of the Arbitration Act, but a question of an exercise of construction which was necessary in order to answer the question posed by Lord Justice Popplewell. And I take the point that there is a challenge to whether he should have been asking that question. But in terms of answering it, we say that there's nothing wrong with construing the LOI in the way that he did.
Even if that's right, isn't it the sort of question which should be left to the factual tribunal?
Well, my Lord, I can see that it would have been better if the Board of Appeal had engaged with the proper construction of the LOI. But in my submission, that does not stop the appellate court on a Section 69 review from themselves looking at that document and coming to a construction, the proper construction of it.
The factors he's relying on are all factual considerations.
My Lord, I think in 69, from the second half of it, I don't think there are any facts which are in dispute. I think he's saying if there was an LOI, a maritime LOI given to the ship owner, then here are the consequences. It would not make sense. Therefore, I reject the payment construction, but I don't think Lord Justice Popplewell is there basing his construction of the LOI on the subsequent finding at paragraph 70 that the bills of lading were presented to the ship owner to obtain release of the goods.
Right, but he seems to be looking at factual probabilities. Anyway, there it is.
Yes, I take the point. I think what I would say is he's testing rival constructions as a matter of commercial common sense rather than making new findings of fact in that paragraph 69, which is an element of construction of the contract in our submission. And the question that the court was seeking to answer by construing the LOI there was whether, in light of that LOI and the subsequent addenda, the contract remained one on CNF-FO terms. And that, too, we say, is a question of construction rather than one of fact. Was the contract, in light of the LOI and the addenda, a contract CNF-FO Mundra? In my submission, the construction of the LOI at paragraph 69 justifies the conclusion that it was no longer a contract CNF-FO Mundra because the LOI envisages discharge of the goods against the bills of lading before delivery to Sharp. So the bills of lading no longer retain their quality as a document of title because the ship owner no longer has possession. That's what's envisaged by the LOI. That's what's agreed in the LOI. So we would say that having conducted that exercise of construction at paragraph 69, it's legitimate to go on to paragraph 71 and conclude that this is no longer a CNF-FO contract because...
You say it's not necessary for them to make a finding, in inverted commas, as to whether there was in fact discharge against the bill of lading.
My Lord, that is the point. I will come on to the second challenge in a moment, but that, I think, my Lord Hampden, you have the gist of the submission, which is that paragraph 70 is not necessary to paragraph 71 because of the construction at paragraph 69.
Even if it were all a question of law, is it permissible for the court to decide a question which it is asked by on the basis of various decisions of law on matters which the tribunal was never asked?
My Lord, I think that we have to accept that the Section 69(3)(b) proviso needs to be satisfied when one's refining the question of law. So the fact that the question has to be the question of law that the Court of Appeal is asking has to be one which the tribunal was asked to determine in the language of the Act. But we would say that when conducting this analysis, this is at a more granular level of detail, what is the construction of the LOI is not itself it's a subsidiary question. It doesn't need to be asked in the terms of the question of law in order to answer the question of law, was the contract as amended CNFFO Mundra? If I may,
there seems to be an assumption that just because the LOI is contractual in nature, that therefore it varies, it amends the original contract. This LOI was made, as I understand it, in the context that the buyers are already in breach by not paying at the due time and exposing the sellers, I think it's the sellers, to demurrage. Although ultimately the buyers would have to pick up the bill, presumably.
I think it may be the buyers, my Lord, but yes.
Ultimately the buyers, but as between, I mean, who was liable for the demurrage to the shipowner, presumably the sellers?
It would be the... my leader's telling me it would be the sellers. I'm just trying to work through it as a CNF contract.
It's going to expose somebody to demurrage.
Yes.
And the purpose of this arrangement, albeit assuming it was contractual, was to try and reduce the fallout from the buyer's breach. But that doesn't mean that it was designed to alter the rights and remedies of the seller arising from the buyer's breach, does it necessarily? That's another question, which may be a question of law, or it may be a mixed question of law and fact.
My Lord, I think I would answer that this way. The LOI acknowledges and agrees that delivery will no longer be by tendering the bills of lading, because the LOI envisages that the bills of lading will be tendered to the vessel before delivery is effected. And therefore, the contractual obligations, the rights and obligations of the parties can no longer entail the seller, Viterra, giving the bills of lading to the buyer in order for the buyer to go to the ship and get...
But this is all by way of trying to manage the loss consequences of a buyer's breach.
Yes.
Why should it be assumed to be otherwise than without prejudice to the buyer's rights under the original contract so far as the seller's rights so far as he suffered loss is concerned?
Well, my Lord,
Why should the seller have to compromise his claims arising out of breach merely by virtue of the fact that he has made a sensible arrangement with the buyer to limit the fallout arising from the buyer's default?
I think the answer to that, my Lord, may be that the GAFTA default clause requires the goods to be valued on the date of default.
Yeah.
If in this situation that means on the terms in existence on the date of default, a substitute contract on those terms, then the default clause tells us on Viterra's case to replicate those terms.
Well, we know in this case that date of default doesn't mean literally date of breach. It means the date the innocent party gets possession of the goods.
Yes, that's the Board of Appeals finding. I fear I haven't answered your Lordship's question.
Yeah. You may not have to answer it in the sense of giving me a fully fledged answer to the problem. All I'm suggesting is it throws up another issue, possibly an issue of law, possibly a mixed issue of fact and law, about what consequences in terms of the seller's rights under the original contract were intended to flow from the fact that the parties have made a sensible arrangement to mitigate the fallout.
Yes, and I can...
Seems to me quite a large issue and not dealt with by the arbitrators.
No, or the Court of Appeal. I suppose that analytically the amendment or the new contract, the LOI contract, may or may not be intended to change the GAFTA default clause. and how it operates.
That's the point.
Yes.
It seems to be a currently unresolved point.
Yes. What I would say is that
it's save insofar as we've got the trenchant finding of the board that this remained a contract for international delivery, not a delivery ex-warehouse.
We have a finding that the contract was CNF FO Mundra. I'm not sure that the finding is necessarily that it was not amended or that the goods should be valued on the basis of the contract as it was originally entered into. No. That is not clear to me from paragraph 7.36 of the award.
I agree.
And in any event, we would say whether it was because they didn't think the contract had been amended or because they thought the valuation should be on the basis of the contract prior to the amendment, either way that is an error which is capable of review under section 69. The second issue I need to address the court on is the discharge against bills of lading issue, and we can find the relevant passage from the Court of Appeal's judgment at paragraph 69 and 70 of the judgment below, page 163 of the electronic bundle. Paragraph 69, in the second sentence, Lord Justice Popplewell says, not only is there no reference in the awards to a letter of indemnity being provided to the vessel's owners to secure discharge, but the terms of the award are also inconsistent with the goods in the warehouse after discharge being held to the vessel's order. And then at paragraph 70, His Lordship says the obvious inference from that and from the construction of the LOI and various other matters set out in 69, the obvious inference is that the bills of lading ceased to be documents of title, becoming accomplished or exhausted upon delivery against them of the goods to the persons entitled to delivery, i.e. the buyers. We accept that that passage at paragraph 70 contains a factual finding, I should say a factual statement, that the bills of lading were presented to the vessel to obtain discharge. So this is different from the first objection in our submission, because it is a factual statement at paragraph 70 about the circumstances of the case. Now, as I sought to explain earlier, we say it doesn't, it's not necessary because of the construction of the LOI, but if it is necessary to justify the answer given at paragraph 71, which is at the date of default, the contract between the parties had ceased to be a CNF contract, then we say that the court was entitled to proceed on the factual premise that the bills of lading were presented to the vessel to obtain discharge. Before I develop that submission, I'd like to take the court, if I may, to the Baleares, which is relied upon by Viterra to say that the Court of Appeal made an unjustified inference of fact. That's at page 596 of the electronic bundle. In tab 13, this was an arbitration appeal on a question of law under the Arbitration Act 1979, and amongst it concerned the expected readiness clause in a charter party, and amongst other issues was the measure of damages to which the charterers were entitled when they terminated for breach of that clause. I believe yesterday your Lordships were taken to the decision of Lord Justice Steyn. If I may take you back there briefly, it's page 608. And can I ask the court first to read from the very bottom of that page at the start of Lord Justice Steyn's judgment over the page, the first 6 lines up until the full and unqualified acceptance of the findings of fact.
You take issue with any of this?
No, my Lord, I was just going to put the statement relied upon by the appellants in what I say is some relevant context, if I may, just by reference to a few passages in Lord Justice Staines' judgment here. That next, after we get to the end of that paragraph, the next paragraph, from time to time attempts are made to circumvent the rule that the arbitrator's findings of fact are conclusive. There are then listed a number of ways in which the arbitrator's facts are subject to collateral challenge on an appeal. One of those starts at the bottom of the first column, parties sometimes, and then onto the next page, resort to more oblique ways of challenging the arbitrator's findings of fact. The court is asked to draw reasonable inferences from the arbitrator's findings of... the court is asked to draw reasonable inferences from the arbitrator's findings of fact. The purpose is often to put forward a new legal argument which was never advanced before the arbitrators. That's contrary to principle. The only inferences which a court might arguably be able to draw from arbitrators' findings of fact are those which are truly beyond rational argument. That's the phrase that's relied upon by Viterra. And then the list concludes a little bit further down with this catalogue of challenges to arbitrators' findings of fact points to the need for constant vigilance. We fully accept the need for caution when reading into an award a factual finding which is not express, to ensure that the factual findings in the award are not subject to collateral attack on appeal, and certainly take no issue with that. However, we would say that where the court is tasked with determining whether the tribunal has erred on a question of law which satisfies the statutory criteria, including section 69(3)b, the court should do so by looking at the facts as a whole, including any implicit factual findings which can be derived from the express factual findings, as well as the factual findings that are expressed in the award. And in my submission, in those circumstances, that's a different situation to the one being considered by Lord Justice Steyn in the Baleares, which is attempts to challenge findings of fact by making further factual inferences to support a legal argument which does not meet the section 69(3)b proviso. And we would say that the test that the court...
What about the passage in Muscle and Boyd to which he refers? That's talking quite generally, isn't it?
Yes, my Lord. I think Muscle and Boyd there are suggesting that any factual inference is not permissible.
Can't do any, they say.
Yes.
Lord Steyn says you can't do it on if it's reasonable. It's got to be beyond rational argument.
Yes, he does. And what we would say is that if the express findings of fact leave only one scenario available, so the only further factual premise that's consistent with the express findings is premise A and not premise B, then when considering a Section 69 appeal, you can proceed on the basis that premise A is correct and premise B is not correct.
But do you have to accept, you'd have to show it's beyond rational argument that premise B is correct?
My Lord, I don't think we would. And can I take your Lordship to Lord Justice Neal's decision in this same case, with which Lord Justice Ralph Gibson agreed to try to make good that submission. If we look at page 607, there is an issue about remoteness of damage. There's a heading there, remoteness of damage, on page 607. And the owner's argument is set out in the paragraph underneath remoteness of damage. I could just ask the court to review that paragraph. Having set out the owner's argument, Lord Justice Neal then sets out a paragraph from the award and says on the following page, 608, that that finding does not fully meet the points raised on behalf of the owners. Nevertheless, His Lordship was satisfied on the facts of this case that the arbitrator's decision can be supported in relation to remoteness, and that the judges adopted too restrictive an approach. And then in the next paragraph on page 608, Lord Justice Neal says in the fourth line, it seems to me that it is implicit in the arbitrator's conclusion that though the owners had no knowledge of the existence of the terms of the specific trade or specific contracts made by the charterers, they must have realised that it was not unlikely that the charterers would have made forward sales at a fixed price. And in column 2, in the first full paragraph, about halfway down, they rejected the submission that the owners had any knowledge of the specific contracts, but I am satisfied that paragraphs 36 and 37 of the reasons are only consistent with an implicit finding that the arbitrators, by the arbitrators, that the charterers would have suffered a trading loss because of the likely course of dealing which they followed. And Lord Justice Neal does not apply a beyond rational argument test here. He just looks at what has been found and decides that it is only consistent with a further implicit finding that the owners did have the knowledge required to satisfy the remoteness requirement. My Lords, I'm conscious of the time, so if I may, I will go on to the facts here.
Is there, apart from Mustle and Boyd, is there any other text which discusses this particular issue?
My Lord, I don't believe there is anything in the bundle to that effect, and so I don't think I can assist your Lordship on that question. I suspect there is some discussion of that.
Simply quoting a document in an award isn't making a finding, is it, apart from the fact that document has been sent? I mean, you're not, as it were, relying on findings of fact the arbitrator's made saying, well, it's like here, some things are implicit in that. You're just pointing to a document that they quote, and then you're drawing conclusions from that, which they didn't draw, either expressly or implicitly.
My Lord, there are 4 points from the award that we take to say that the necessary inference is that the bills of lading were presented to the vessel to obtain discharge. And if I could, I'd take you to those now. Some of them are documents, but we would say that if the documents recorded in the award point towards one scenario being towards only one scenario, then it is legitimate to look at those documents as part of that analysis. The first of the 4 reasons is the express factual finding that Sharp did give an LOI to Viterra at Viterra's request, and the terms of that LOI, and I've already addressed the court on why we say that is only consistent with discharge against bills of lading, because once one construes it correctly, we say that is what the parties agreed. The second point is that the tribunal made factual findings about the efforts which Viterra took to obtain the goods from the warehouse in Mundra, which are inconsistent with the goods being held to the order of the vessel, which is a point I think Mr. Carrier mentioned earlier. I'll take you to one of those, and perhaps I can give you the references to the others, because they really go to the same point. If I could take the court to page 222. Paragraph 3.26. Apologies, can I instead go to page 225? Paragraph 334 of the Lentils Award. The sellers pursued court proceedings in the High Court of Gujarat against buyers as Respondent number 1 and Adani Ports as Respondent number 2 in order to obtain possession of the goods. A consent order was granted on the 2nd February 2018. That is the date when Viterra obtained possession of the goods, which is why it's the date of default. There are also references at paragraph 7.44 to goods being stored at Adani port, which refused to release them to the sellers without the buyer's permission, and also in the same paragraph, that's at page 247 if the court wishes to look at it, to Viterra paying the storage cost to Adani port and not to the ship owners. Those facts, we say, are only consistent with Sharp and not the ship owners holding the keys to the warehouse, as it were. The third point is, if we could look at paragraphs 7.21 to 7.23 on page 240. In my submission, one can derive three facts from paragraph 7.21 to 7.23. The first, it was Viterra who put the goods in the warehouse. We discharged the goods and essentially put them into a warehouse awaiting payment, is what's said at paragraph 7.21. Second, it was Viterra and not the ship owners who agreed to discharge against an LOI, the LOI being discussed at paragraph 7.22. And thirdly, the LOI preserved Viterra's rights over the goods. Again, I get that from 7.22. And the only right which can be preserved by the LOI was the right to control the release of the goods from the Adani warehouse. That would be of no use if the goods were actually held to the order of the vessel rather than the order of the parties. And the fourth and final point is that there's no reference in the awards to the ship owners or to the ship at any time after discharge, or any reference to an LOI being given to the ship owners. As we've just seen, the LOI discussed in the awards is clearly one given by Sharp to Viterra. Therefore, my lords, we submit that if one takes these factual findings in the round, they are entirely consistent with the bills of lading being presented to obtain discharge from the vessel, after which they were held to the order of the parties, and entirely inconsistent with the ship owners retaining possession of the goods, and the bills of lading retained their status as documents of title. And therefore we say it was open to Lord Justice Popplewell and the Court of Appeal to draw the inference they did at paragraph 70 of the judgment below. Unless I can assist the Court further, those are my submissions, and I believe that also concludes Sharp's reply on Viterra's appeal.
Thank you very much, Mr. Gardner. Yes, Mr. Collett.
My Lords, I can be very brief in reply, I hope. Mr. Karia said that he accepts that the tribunal was never asked to decide whether the contract was varied, and if you accept that, then that must be fatal to the Court of Appeal's decision, because one of the questions which they decided, the problematic question, was that the contract was varied. And really, at that point, I don't need to go any further. The only other further observations I could make would be in relation to the factual findings which the court made in order to justify the finding of variation.
What about, I suppose, does it matter whether it's a question of law or a question of fact, how you read the LOI? I mean, are they allowed to go off making conclusions of law on the subsidiary, as it were, to the ultimate question, never part of the issues before the tribunal?
I would say that that is a fact-sensitive question. So if one takes the example of Cottonex, the point about the modification of the question of law in Cottonex from the contract to a contract was to enable the court to have regard to all the terms of the contract and all the terms of the document that was sought to be incorporated, so that the whole of the contract, or the contract, the words of incorporation could be construed in their context in the contract as a whole. And clearly, that exercise might involve testing subsidiary questions of law and looking at other parts of the contract and considering their effect. So I would not go so far as to say that a subsidiary question of law which isn't identified in the main question can never arise for determination. But that is not what happened here. What happened here was that the LOI was purportedly being construed as part of the variation, and in fact, the first step in the analysis was that the LOI was in fact a variation to the contract, whereas, as my Lord Briggs has pointed out, there is a prior question: is this a variation, or is it simply a collateral contract which is made along the way as part of the process of dealing with the default, which doesn't vary the underlying obligations under the addendum, but simply puts in place, the way I put it in the Court of Appeal, was that this was all provisional pending the resolution of the ultimate dispute. And that analysis might well be reinforced by the fact that the addendum then recites expressly all other terms and conditions of the original contract are to remain unchanged, which was a further indication that the parties were proceeding on the basis that none of Viterra's original rights under the contract were being given up. So far as the finding in relation to discharge against bills of lading is concerned, firstly, I say that that was a critical finding along the way to the finding of variation, and that is why the Court of Appeal in Lord Justice Popwell's judgment of paragraph 71 used the word therefore when proceeding to the conclusion, when the preceding paragraph dealt with the discharge against bills of lading and the bills of lading being spent. So far as the LOI is part of that analysis, the Court of Appeal could only get to the conclusion that that was an agreement for discharge against bills of lading by working back from what it thought had actually happened to the bills of lading. So as my learned junior said, the process and the reasoning were entirely circular. But my lords, unless I can assist further, I fear I would simply be repeating the points that I made originally if I were to
Are you aware of any texts apart from Mustle and Boyd?
My lord, I'm not. I did keep an eye out for any discussion and any useful case law. Clearly, on the special case procedure, as Mustle and Boyd makes clear, there was a different latitude. So decisions on special case procedure don't really help. But Mustle and Boyd was the only textbook that I encountered which gave so far as I recall, a clear...
Do we have that in the...
Yes, we do. My learned junior gave us the reference. It's in the electronic bundle.
This is an old... Has it been reappeared in more recent edition?
There's not a more recent edition. What happened in relation to Mustle and Boyd was there was a companion volume.
Yes.
That was brought out when the 1996 Act came in, which is by way of a commentary to the 1996 Act, and I did look at that and I didn't find anything particularly illuminating in it.
There's nothing since, I don't think.
No, there is a new edition promised, but perhaps in 2025.
Right.
Certainly, I don't think it's going to be published in the next few weeks.
Can I ask you about something different? I'm always intrigued by the difference between questions of law and questions of fact. And the argument that Mr. Gardner's given us is, one could boil it down to the proposition that the construction of a contract is a question of law. The Starson tells us that inserting a missing word is a matter of construction, therefore it's a question of law.
Yes.
at the moment I'm a bit sceptical about this, and I'm just thinking aloud. One can see that the meaning of words can be treated as a question of the meaning of the words used in a contract. One would say is a question of law, and one wouldn't admit the evidence of the author in order to ask him what he meant. If the question is, we have a word missing here, is the word that's missing that the author forgot to type? Is that word payment or is it discharge? It strikes me at the moment as a different kind of question, and I'm wondering, would one admit the evidence of the author of the LOI to tell us what the word was that he omitted?
No, on our objective interpretation of contracts.
So you're treating it as a question of interpretation as well?
Well, no, I'm not. Well, in this particular case, it may depend on the circumstances and where the issue arises. But in this particular case, the exercise is clearly a factual issue, because the question is being asked and the answer is being given in relation to the inherent probabilities as to what actually happened.
So it would have to, it's not a case where you could just read the document in its context and understand what it means. It's obvious that they've missed out a word.
Yes.
Sometimes it's the case.
Yes.
You would have to rectify the document in order to, if you were going to make it say what they want it to say,
Yes.
which would require evidence about what it was intended to,
Well,
Yes.
we hope it would.
to say.
Yes. Yes.
Depending on what this court makes, a recent direction view to that effect expressed in the Court of Appeal.
Yes. And the exercise in the Starsin is very different because it related to a standard form.
Yeah.
So one could say objectively, what would users of that standard form intend the contract to say? The most extreme example that I can think of is the case of a standard form bill of lading where the reverse had simply not been printed, and there was an argument, which I think was accepted, that one could read in the standard terms on the basis that this was simply a printing error, and the parties must have intended to incorporate the standard wording. But in another case I was involved in, the parties actually combined the face of one version of the bill of lading with the reverse terms from another, and it was argued against me that therefore the terms should be disregarded because that can't have been what they intended, but the judge didn't accept that.
Yeah.
So it all depends on the context.
Yes, I mean, thinking about the example of wills that Lord Mustall gave, one could imagine a standard clause that appeared in Victorian wills where a word had been omitted, and one could readily work out what was intended.
Yes.
If, on the other hand, it's, I leave Auntie Mildred, and then nothing appears, that wouldn't be a question of construction at all.
No. And this is an extremely dangerous exercise in the context of a commercial document which was written by, we don't know who, but a commercial person, probably in India, in circumstances where we simply don't know all the linguistic conventions and so on that might have been in use. And the construction here the exercise of factually working out what word should have been there but was not would be highly fact-specific, and it's not an exercise which was embarked upon by the tribunal because they didn't need to do it.
Thank you.
We were just showing us the passage. Sorry, I didn't, in Mustall and Boyd.
Oh, yes. Shall I just...
Just with a reference.
Yes, it's page 1105 in the electronic bundle.
Yeah. Note 15.
It sets a high standard of
Goodness.
the inference must flow inevitably from the other facts found.
Yes.
Yes. And he goes on next paragraph to say if that test's satisfied, it's unlikely to be an issue because the parties would agree it.
Yes, quite. Appreciate it. Yes.
That's the old system, though. So he's saying it's even stronger than that now.
Yes.
according to Mustill.
Yes.
There's a very oblique reference to Order 59, Rule 10.3, under Note 15 in the previous paragraph.
Yes.
It's been a long time running that down unless it's been helpfully. Quite apart from anything else, you have to work out which version, which year of the White Book.
Yes. We did look at it, didn't we? Yes. We did follow up the footnotes, and we didn't find anything that was particularly illuminating.
The 1989 White Book.
My Lords, unless I can assist further on the Section 69 appeal, I was proposing to turn to the cross appeal.
Yes.
And on that, I will make my submissions under 4 headings. Firstly, high-level points of principle. Secondly, the correct approach to construction of the default clause. Thirdly, the key authorities, which are Bunge, Eurometal, and the caloric. And fourthly, the question, are there circumstances in which actual or estimated value is not to be determined by reference to a notional substitute contract on the same terms as the unfulfilled contract? So, starting with high-level points of principle, I'm hopefully going to engage with what seems to be the issue at the heart of the appeal, which is the contract market measure. And I accept that there is a conceptual difference in the application of that measure as between cases of non-delivery and non-acceptance. In a case of non-delivery, the buyer has lost goods which it had agreed to purchase on particular terms. The availability of a market for substitute goods to be purchased on the same terms allows the buyer to mitigate that loss. The buyer is therefore put in the same position as if the contract had been performed by purchasing such substitute goods or being deemed to have done so if it did not. In a case of non-acceptance, the buyer has lost the price which was payable for goods sold on particular terms.
Seller's loss.
Selling.
Sorry, yes. It's an error, yes. My note. The availability of a market for substitute goods to be sold allows the seller to mitigate that loss. The seller is therefore put in the same position as if the contract had been performed by selling such substitute goods or being deemed to have done so if it did not.
Well,
at least the differential.
It's partly
yes.
put towards that position,
Yes.
and then the gap has to be made up by the.
Yes, it's the differential then that is their remaining loss.
It's getting part of the price that the buyer should have paid.
Yes.
Maybe even the whole price.
Yes.
In which case there's no loss.
Yes.
See, substitute goods to be sold. What do you mean by that?
Well, I'm going to turn to that because that is really the issue here. Well, the issue which yesterday's argument brought into focus in the context of the question of whether there is an available market, or perhaps I should have said a substitute sale rather than substitute goods, when we're talking about an available market for a substitute sale, are we talking about an available market for a substitute sale on the same terms as the unfulfilled contract, particularly with reference to the prima facie rule in section 50, subsection 3 of the Sale of Goods Act? Because that is really the issue that underlies the question of construction about subclause C and whether Viterra's construction is right or not. It appears to be uncontroversial that it does matter whether the substitute contract is on the same terms in a case of non-delivery, because the mitigation or the deemed mitigation would be imperfect if the substitute contract was not on the same terms as the original contract.
Why does the mitigation have to be perfect? It's almost by definition going to be imperfect, and the measure of the imperfection identifies the amount of damages that have to be paid in addition.
Well, not on, in a general case of mitigation, yes, that may well be true, but in the case of the prima facie measure under section 51, subsection 3, all you get is the difference between the contract price and the market or current price. And so for that exercise, the market price has to represent good mitigation. Otherwise, that measure, that prima facie measure, will be an imperfect measure. Or it won't apply because although it's the prima facie rule, it's displaced by the general rule in subsection 2.
Your hypothetical substitute contract has to, for example, be the same quantity and description of the goods.
Yes.
In any, on any view.
Yes. And as support for that proposition, I can take the facts of the Eleanor de Amico, which we have in the authorities electronic bundle at tab 18. Page 772. The overarching point about the Eleanor de Amico is that it's a case of repudiation by owners, and therefore it's analogous to a non-delivery. And a key fact in that case was a feature of the contract which we can see from page 780 in the right-hand column. halfway down, so it's the third paragraph beginning, I must now refer to some of the findings of fact in the special case. The special provision that's relevant is that under the charter party, the ship was described as Italian. So it's a charter party not for any vessel, but for an Italian flagged vessel. And that then fed into the arbitrator's analysis and decision in relation to the market price or the market rate. And we see that at page 781. In the right-hand column, the quotation from paragraph 12 of the award. There's a discussion, firstly, of a market for vessels of varying nationality, and then a more limited market for vessels flying the Italian flag, which the arbitrator refers to as the world time charter market and the Italian time charter market. And then if you go down to the end of the quotation from paragraph 14, penultimate paragraph on page 781, the arbitrator concluded that the market rate for an Italian flag vessel was $4.30. And he then awarded damages based on a market rate for an Italian flagged vessel. And that decision was upheld by Mr. Justice Robert Goff at page 787 in the left-hand column. Really the last two paragraphs. So that was the context in which Mr. Justice Robert Goff was making his discussion of principle, and you've seen the discussion of principle on page 784, which my learned friend showed you earlier, and there is the similar discussion on page 786. And perhaps the passages to emphasize on 786 are firstly in the left-hand column, the paragraph beginning now where, as for example. And also the passage at the foot of that column dealing with the independent decision of the innocent party not to go into the market. So the propositions for which Elena D'Amico is authority are firstly that where there is an available market, the contract market measure applies regardless of whether the innocent party takes advantage of it. The underlying premise of both the arbitrator and the judge's decision in the case was that available market meant a market for a charter on the same terms, i.e. Italian flag. And the third proposition, third point, is that the contract market measure is not exhaustive of mitigation. For example, where a compensating benefit falls to be taken into account on British Westinghouse principles. And sorry, I should have asked you to read the top right hand of page 786, the discussion of Panyan and Corbiza, which gives an example of such a compensating benefit. So I say that the Eleanor D'Amico supports the proposition that at least for non-delivery and analogous cases, available market refers to an available market for a true substitute contract, i.e. a contract on the same terms.
It doesn't say that every single term has to be supposed to be a replica. Obviously, it has to be for a similar item. You know, if you're looking at a market for different kind of lentils from Canadian lentils, that wouldn't be a comparable price. But it doesn't suppose that you have to imagine you're selling the goods from Vancouver all over again, rather than selling them where they are in Mundra.
Well, that begs the question. At
the moment we're looking at seller default.
Yes.
So I think my Lord's question is where one jump ahead, but I'm sure the same question could be asked in relation to seller default.
Well, yes. So in relation to seller default, I do say that the material terms have to be the same for the available market measure. The issue here may be that there may be circumstances under the Common Law or under the Sale of Goods Act, Section 51, where the prima facie measure based on the available market is displaced for some reason, and it could be that the fact that in the context of a seller default, the buyer needs goods in a particular place at a particular time and they're not going to arrive by that time under a substitute contract, means that it's reasonable mitigation to buy prompt goods somewhere else. But that is a case outside of Section 51, subsection 3. And so it doesn't help us as to the meaning of the market measure and an available market under Section 51, subsection 3. I was going to move on to authority supporting the same proposition in relation to non-acceptance. And the first authority is in the supplementary authorities bundle at tab 10.
We don't have tabs.
Oh, sorry. Yes, I've been... I will just give you the page number. It's page 503.
Sorry, whose supplementary authorities?
So this is the supplementary bundle, the large supplementary bundle, not the Respondent supplementary bundle, our bundle.
And sorry, what page? I was on the
page 503.
503. Is this Solicitor's Journal?
Yes. So I'm sorry that this is not a particularly legible report. This is a facsimile, but when I went to the library to get the original, it had turned brown and was incapable of being photocopied, so, because of the poor quality of the paper being used. But if one can take what needs to be taken from the passage beginning with the name of the judge, Mr. Justice Horridge, about halfway down the right-hand side on page 503, essentially what happened was that a horse had been sold, warranted, sound in wind, quick and a good worker, but was wrongfully rejected. It was then resold as being in dispute, which meant that it was sold without warranty, one might say, as is. The seller brought a claim for the price and that price failed, that claim failed. The alternative claim for damages also failed because the resale price was held not to be evidence of the loss, essentially, of the value of the contract which had been lost. And the key passage is towards the end of the column. Perhaps the sentence, under those circumstances, the judge was right in saying that as the case was put before him, there was no damage shown at all, the auction being no guide because it was held under different conditions of sale.
It's not a Section 51 case.
Well, it is put as a Section 48 case, but in my submission, Section 48 of the 1893 Act then just took you to Section 51. So I would say it's a Section 51 case. I know that Section 51 isn't cited. Section 51, if I believe I'm right in saying, is not cited in any of the authorities that we've looked at squarely.
Yes, but he is referring to specific sections of the Act.
Yes, but that was because he started off from the question of whether...
I can well see that a horse that is warranted sound is a different animal to buy than one which is sold as in dispute, so it's not comparable.
Yes.
But there's no case that you've pointed to yet which suggests that it's appropriate to assume a sale in a different market from the one that's most reasonably available, because the terms of the contract somehow force you to make that assumption.
Well, one has to unpick that, though, because here, what I'm focusing on is what would be applicable under Section 50, subsection 3, the prima facie measure by reference to an available market. And I'm seeking to address an available market in what? What does that require in terms of the ability to resell and the terms of that resale? Now, we know that Section 50, subsection 3 is only a prima facie measure. We know that it can be displaced by other principles, and there may well be circumstances under the Sale of Goods Act regime where the most appropriate measure is based on different terms of sale.
But I see it as coming in before you get to the market. There's a question of which market is it reasonable to mitigate your loss in.
Well,
and sometimes it's where you are, and sometimes it might not be. And then you assess the price by reference to that market.
I would take issue with the concept of a market being in a particular place, which I would say is, firstly, anachronistic, and secondly, not the underlying issue here. We're not concerned with a market in a particular place. We're concerned with the terms upon which the substitute contract of sale can be made. After all, if...
Sorry, carry on.
I was going to say, if you, sitting in London, can contract with a broker in New York to sell the goods in India, it is meaningless to talk about the market being in India. What you're disputing or debating here is what are the appropriate terms in the circumstances in which you find yourself.
Yeah, I accept that.
Isn't this an important difference between a buyer's default and a seller's default? In a seller's default case, the buyer has lost the goods. Yeah. And insofar as the particular terms of the contract are descriptive of the goods, then it's very important to use as a yardstick for his loss that description. But in the case of a buyer's default, all the seller's lost is money. And therefore, what the seller is seeking to do in mitigation is get his money by disposing of the goods in whatever market he can most reasonably and conveniently turn them into money.
Can I politely cavil with,
yes, please do.
with the proposition that all that the seller has lost is money? What I would say is what the seller has lost is the money payable for the contractual performance which the seller had promised to make by the terms of their contract.
Yes, but in this case, the seller has performed.
Well, yes, but that's but that's a slightly different point. My point is you cannot divorce the contractual price from the terms of sale.
Well, that is the issue, isn't it?
Well, but to take a very simple example, really the example we've just been looking at in Macklin, clearly the terms of any warranty as to quality or condition are highly material to the price. And if we suppose the opposite example from Macklin, where the goods on the original contract were sold with no warranty of quality or a very low warranty of quality which merited a low price, and if we then assume that on the substitute sale the seller offered the goods and concluded a contract with a high warranty of quality which merited a higher price, I say there would be at least an argument that the benefit of that higher warranty was an independent speculation by the seller and therefore did not fall to be taken into account when it came to assessing damages and the extent that the resale was mitigatory. And you can test that because offering a higher warranty of quality increases the risk to the seller. And the risk, the seller may be willing to take that risk for an enhanced price, but that is an entirely separate matter from the risk that they were undertaking under the original terms. And so I do say that price and the terms are intimately linked, inherently linked. One cannot divorce one from the other. And that is why the starting point in relation to Section 50, subsection 3, is a substitute contract on the same terms, materially on the same terms. I accept, I'm perhaps jumping ahead slightly here, but I accept that there are circumstances where some terms which are important are altered in the substitute, and the most obvious example of that is with charter party repudiation. I'm going to come on in a moment to the Golden Victory, but it is trite law that where there is a repudiation of a time charter, the substitute contract is, in the context of asking whether there's an available market, is to be on the same terms as the original, save as to price, and also save as to duration, because at that point you're looking at a contract for the unexpired balance of the repudiated charter and not the original term. And that could, in some circumstances, be a very significant difference, because the market for 2-year time charters can be different from the market for 10-year charters, say.
Well, perhaps the analogy here is that what you're looking at is not a non-acceptance before the goods have left Vancouver, but a non-acceptance after the contract, after there's been a part performance and the goods are now in Mundra. And so it's not analogous to look at what it would cost to replicate the process of purchase in Vancouver and carriage to Mundra.
But that's a different type of change. That's a much more, if you're positing a substitute sale which is on different commercial terms as to delivery, which is the essence here, that is a much more fundamental change. It's going to have a much more fundamental effect on the price. It may well be that that can be accommodated within the Common Law and the Sale of Goods Act. But the question for us is whether that is accommodated within the default clause, or whether the default clause provides a much simpler mechanism, which is essentially a financial closing out of the transaction on values that can easily be ascertained or estimated by a broker or a tribunal.
Well, that's a different argument from what I thought was your argument up to now, which was under the Common Law and Sale of Goods Act.
Well,
this is the appropriate measure.
No, I'm not resiling from that argument.
No, but you're putting an alternative one in play.
No, what I'm saying is that the alternative contract on the same terms is only relevant where you're talking about an available market in the true sense. And it may be that in many cases there is not an available market in the true, strict sense. And it may be that that's why you look at other measures. But that doesn't detract from the starting point, the purest point, where you genuinely do have an available market. You are looking at an alternative on the same terms.
Why not on the same terms insofar as the contract hasn't already been performed?
Because the difference in terms of performance may make a very considerable difference to the price. If you are comparing a CNF contract with a delivered ex-ship contract, clearly there are going to be different incidences in terms of passing of risk, and there are going to be pricing differences as a result. If you take it one step further and posit a CNF contract versus an ex-warehouse contract, a landed contract, then there are going to be even further differences. And so at that point, you are moving very far away from the concept of an available market.
They're all differences that would have benefited the buyer if the goods had been handed over, so I don't see why they shouldn't benefit the seller.
The question, though, here is a much more narrow one, which is what is the mechanism in subclause C, because that's all that the question of law is concerned with. These may all be perfectly good points, and it may be that there are other ways that these benefits could have been taken into account outside subclause C, but that's not the debate here. The debate is to get to the right meaning of subclause C.
Which one would think should be interpreted with an eye on the compensatory principle.
Well, one would think that the entire default clause should be interpreted with an eye on the compensatory principle, but that doesn't necessarily tell you what part subclause C has to play within that mechanism.
Well, the principal issue here is whether it identifies the goods as the goods in the warehouse.
Well, I'll come on to that, but again, that in my submission, that's an oversimplification to talk about the goods as if we're really just concerned with a pile of coal or a hold full of lentils in the context of a CNF contract, which is essentially a contract for the sale of documents representing goods. I mean, I know that may be overstating it in the sense to suggest that the underlying goods have no relevance at all.
But it does come within the Sale of Goods Act, so...
It does come within the Sale of Goods Act, but conceptually what we're concerned with is a party purchasing a bundle of rights, which they're going to acquire through the tender of transferable documents, particularly in a CNF contract, the bill of lading, and in a CIF contract, also the insurance contract. And so to talk about the goods as if we're only concerned with what is the realizable value of those goods as chattels simpliciter, I would say is already moving quite far away from the actual transaction which is under consideration here.
But if you're not challenging the date of default, as at the date of default, I mean, the date of default is identified by reference to the point at which the goods fell back into the possession of the sellers, rather than the documents of title, which, well, we don't know, do we?
Yeah, but with respect, I would say that not much weight can be placed on the board's finding as to the date of default in terms of analysis. It's not a date that has been challenged by either party.
No, but it seems to be common ground, and it wasn't challenged before the arbitrators, that the date of default is the date when the seller is able to dispose of the goods. He ceases to be a locked-in seller.
Well, I don't accept that that's a general principle for this default clause, because this default clause has its own provisions about the default date, which are different from that. Perhaps we should just look at that if we're on that point. The contract itself is in the electronic core bundle, and the default clause is on page 312. I should say there is a great deal of case law about the date of default under varying forms of these contracts, and it's not a straightforward question. But here we have a specific provision in little letter f by lines 375 and following. Default may be declared by sellers at any time after expiry of the contract period, and the default date shall then be the first business day after the date of seller's advice to their buyers. Now, there might be a question mark about what's meant by expiry of the contract period, as to whether that means the time for shipment or the time for payment, and whether it varies depending on whether payment is to be by letter of credit, which would be opened before shipment, or here where there was a cash against documents arrangement prior to discharge. But putting aside the question mark about what expiry of the contract period means, this particular clause seems to give the seller the option of fixing the default date by giving notice, by giving the advice, and it doesn't say anything at all about the ability to resell the goods being determinative of the default date, nor does it say anything about the arbitrators having the power to fix their own default date differently from the mechanism in subclause F. And you'll notice that there's a different provision in relation to default by the sellers if the sellers fail to give notice of appropriation, and that hasn't been served by the 10th consecutive day after the last day for appropriation laid down in the contract, the sellers shall be deemed to be in default, and the default date shall then be the first business day thereafter. So there's a mechanism, there's no option. It's simply, there's a hard stop and a deemed default date. But that rather illustrates the danger of reading over anything that's said in Bremer about the default date into this particular contract, because it has its own mechanism, and as to whether and how the board's finding is to be reconciled with that, that's just not the matter we're concerned with, so it just doesn't assist. One other point which might be made here on the default date is that even on the Bremer approach, there is a difference between the default clause and the common law. Because, I say the common law, the common law as codified in the Sale of Goods Act. Because in the Sale of Goods Act, the date for determination is the date when the goods should have been accepted, etc. Whereas under Bremer, it's the day after. Well,
it happened to be the day after on Bremer.
Yes.
It could be a week after on different facts.
Well, as the default, the rationale there was that you couldn't have a default date that was the last day for performance, because that would be inconsistent with the idea of going out into the market. But if that's
so there can be other situations in which it takes longer to go out into the market, and it's appropriate to choose a different date.
Well, that is true, but what the Act says is that you're looking at whether there's an available market on the last day for performance, which is itself an arbitrary rule, and it's an observation that's made by Professor Bridge in his article, which takes a slightly different view from Professor Kramer. But anyway, we don't need to go into that.
Anyway, it's a prima facie rule. So.
It's a prima facie rule, but it's another indication that one can't assume that these default clauses are simply replicating the law in the Sale of Goods Act or the common law. Sometimes contractual choices may be being made that lead to a departure from that position. The next authority I was going to take you to was the Golden Victory, which is in the electronic bundle, page 617. as we know, the Golden Victory was a case of repudiation by the charterer. So in that sense, it's analogous to a case of non-acceptance, because to put it in the terms that we've been using, the owner is left with a vessel on its hands. That's the right way of looking at it. And my submission is, well, as I've said, the case law generally proceeds on the basis that there is only an available market in this time charter context if the owner can obtain a substitute charter on the same terms, save as to rate and duration. And as I've said, the duration of the substitute charter is taken to be the unexpired balance of the repudiated charter. I'd like to just show you three passages in the speeches in the Golden Victory. Firstly, at page 634,
Six.
634,
Okay.
in the speech of Lord Bingham, who was in the minority, paragraph 10 at the foot of page 634 and over to the top of page 635, you will see that he endorses the Eleanor D'Amico, which, as I've said, was premised on a substitute on the same terms as the repudiated contract. The second passage is on page 657 in the speech of Lord Carswell, paragraph 67, where he says, first, it is a necessary assumption in estimating the damages that the hypothetical new charter party, taken to have been negotiated by the owners in early 2002, would have contained terms which corresponded as closely as possible to those of the original charter party, including the cancellation provision in clause 33. So that is a statement that it should be assumed that the substitute is on the same terms as the original charter party materially. Here, of course, it mattered because the assumption was that the war cancellation clause would be in the substitute as well as the original charter party.
Can you just give me the page number again?
Yes, I'm sorry, it's page 657.
Thank you, I got it. Yeah.
Paragraph?
Paragraph 67, so it's just after the citation from, I'm not sure how to pronounce the Welsh case, regarding the artificiality of ignoring what has actually happened.
Yeah.
And the final citation is at page 662. And this is from the speech of Lord Brown in paragraph 82 towards the foot of the page by letter F. Any substitute contract here, albeit as the arbitrator found for the 4-year balance of the original 7-year term, would have been subject to the self-same conditions as the repudiated contract. So we have two express statements by the majority that the substitute is to be on the same terms as the original contract. And in Lord Bingham's speech, although he doesn't touch on that particular point. He does cite the Eleanor D'Amico, which, as I've said, has underlying it the same premise. And I'm citing the Golden Victory by way of run-in to Bungi and Nadira, because the reasoning in the Golden Victory very much underpins the reasoning, particularly of Lord Sumption, in Bungi and Nadira. And if one wants to ask where the emphasis on the substitute contract being on the same terms comes from, the answer is essentially from these passages in the Golden Victory. And these passages are all in the context of a situation under a time charter party which is analogous to a case of non-acceptance. So that is the background by which it comes to be said in Bungi and Nadira as essentially incontrovertible that in both non-delivery and non-acceptance cases, the notional substitute is to be on the same terms as the original contract.
But if you imagine the part, if it's the balance of a time charter in this case, the ship will have moved from where it was at the time of the original charter. And although an awful lot of the terms of the hypothetical contract might have to be the same, they would have to take into account where the ship had got to by the time of the repudiation, wouldn't they?
Yes, but
suppose the original charter was from London to Mumbai, and the ship was in Mumbai, but, well, it was unlikely to be repudiation at that point, but let's say the ship had got 2/3 of the way there. Your equivalent market for a contract for the balance of the charter would hardly start with the ship in London.
That is perfectly true.
Treating the ship as a sort of analogy for the goods.
Yes, it's perfectly true, but the position of the ship is not a good analogy for the commercial terms under the sale contract, because that is likely to be much less important, particularly in a long-term time charter, to the market rate than the commercial terms that we're discussing here, the difference between CFR and anything else.
But it might be important in a voyage charter. Or...
Yes, but in a voyage charter, you don't get this analysis of an available market, because in a voyage charter situation, you generally move straight to actual mitigation. And then you get into complicated issues of overlap and so on, in cases like the Null Bay and the Concordia Sea and other cases. So one very rarely, in a single voyage charter situation, where the voyage charter is repudiated partway through or very close to the laycan, one doesn't really get into questions of available market and perfect substitutes. One just gets into reasonable mitigation. And then because the reasonable mitigation will usually involve a charter of a different length and maybe to a different place, you have a question about the overlap or the underlap, and you also have a question about where the vessel is redelivered and whether that is better or worse, and whether that falls to be taken into account by way of some adjustment for repositioning.
But if in the present case the goods have got not merely to their point of discharge, but through a customs barrier through which they passed without having to make a payment, but through which any substitute goods could not pass without having to make a substantial payment, might that not be a rather powerful consideration favouring a substitute contract for the sale of goods where they have reached?
Well,
even if not an invariable rule.
In the Common Law Sale of Goods Act world, that may well be a factor that can be taken into account.
Why not under clause?
Well, that's what we're dealing with,
yes.
With Golden Victory
yes.
and so forth.
Yes, but the Golden Victory, again, the underlying point here may be that there is not an available market for a substitute sale in those circumstances. And so in the Common Law Sale of Goods Act world, we're simply outside of the letter of Section 50, subsection 3, and we're into reasonable mitigation.
Which involves just adjusting it, like like you might the date.
Yes, quite, yes. Yes, I mean...
and then you apply a similar principle of, what's the market price on that date, or market price in this place.
Yes. The debate is not about whether any of this is a proper way of achieving the compensatory principle, and that taking into account what has actually happened is irrelevant in all circumstances. The debate is about whether that happens within the Section 50, subsection 3 mechanism or outside of it. And that is very important to Lord Sumption's construction of the default clause, because of the emphasis he places on the Section 50, subsection 3 mechanism and the scope of subclause C in relation to that.
Well, you'll be coming to that, but
Yes.
I thought he interpreted it as essentially fulfilling the compensatory principle.
He interprets the default clause as a whole as fulfilling the compensatory principle by limiting the scope of subclause C to movements in price, and saying that other aspects of the compensatory principle, such as mitigation and consequence events in the golden victory sense, can be taken into account outside of the subclause C mechanism.
Okay, well, it'll probably be showing us that.
Yes, but that's the technique. So yes, that is the overall effect of the default clause on his construction, but it is reached through putting a precise limit on the function of subclause C, which is tied in to Section 50, subsection 3 and 51, subsection 3, which is why it's important to be precise about what they actually mean. So I'm going to move on now to Bungi and Nadira, which is at page 521 of this bundle. And beginning with the judgment of Lord Sumption, the first passage I would pick up is at page 528, paragraph 14. Paragraph 14 is dealing with the common law measure, and the important section is halfway through the paragraph, where he says, in a contract of sale where there is an available market, and pausing there, that's an important qualification, and I say he's using available market in the Section 50, subsection 3 sense. This is ordinarily achieved by comparing the contract price with the price that would have been agreed under a notional substitute contract, assumed to have been entered into in its place at the market rate, but otherwise on the same terms. So pausing there, that is his statement about the common law principle where there's an available market. And my learned friend hasn't suggested that that is wrong, as I understand it, and it is grounded, firstly, in the golden victory, and secondly, I would say, in an assumption that was almost so obvious that it didn't need to be said in any of the earlier cases, except perhaps insofar as it's underlying the thought in the Macklin judgment. But this is his starting off point for discussing Section 51 and Section 50 of the Sale of Goods Act. So he starts off by stating that as a general principle applicable where there is an available market, and that is firmly tied to the proposition that the terms should be the same in relation to the substitute. Then he cites section 51, subsection 3, damages for non-delivery, but he then expressly refers to section 50, containing corresponding provisions for non-acceptance by the buyer. So clearly, although, as I've acknowledged, one cannot mechanically treat the cases of non-delivery and non-acceptance as mirror images of one another, he is still focusing on both, and his observations are intended to apply to both. Then in 16, he says that those sections reproduce the 1893 Act and reflect the common law principles which had already been established at the time of the earlier Act. So pausing there, that's a reference back to 14, and what he is saying is the common law principle where there's an available market is that the substitute is on the same terms. And then he essentially goes on to discuss the relationship between subsection 2 and subsection 3 and moves on from there to the problems of anticipatory breach, which is not our problem. So what we get from 14 through to halfway through 16 is an express statement that the Sale of Goods Act reflects the common law principles, and that in relation to subsection 3 of sections 50 and 51, they are reflecting the principle that where there's an available market, the contract assumed to have been entered into in place of the repudiated contract is to be otherwise on the same terms as that contract. So what I draw from that in summary is that the contract market measure does presuppose that there is an available market for a substitute contract on the same terms, both in cases of non-delivery and in cases of non-acceptance. I accept that there may well be cases of non-acceptance where there is no available market, and in those circumstances where it represents reasonable mitigation to resell on different terms. And in that case, the measure will be contract versus available reasonable mitigation. In other cases, as I've said, a decision to resell on different terms may be an independent speculation in the Elena de Amico sense. For example, where, as I've said, the quality terms are more stringent and attract a higher price. The cases that my learned friend has cited on the common law, Barrow and Arnaud and Napier and Dexter's, do not assist because they do not distinguish between, firstly, the case of deemed mitigation by virtue of an available market for a true substitute, and secondly, what might be reasonable mitigation in the absence of an available market. Neither of those cases engages in any way with that question, which is rather at the heart of the issue that we have before us. And finally, just to reiterate the point that I've already made, references to sales in a particular market is apt to obscure the real issue, which is not the physical place of the substitute transaction, but the terms of the substitute transaction. That takes me to the end of that first section, and as it's 1 or 2 minutes to 1, that might be a convenient moment.
Yes, certainly, that's convenient. We'll resume at 2 o'clock, and in the meantime adjourn.